Item number 1.
The order dated 18th of May 2026, the divisional application number has been typed as CR321 of 2024 instead of 2023.
That is only. The matters is to be mentioned for correction in the order dated 18th May 2026. And counsel for the petition draws the attention of this court that the case number is inadvertently recorded as CRR 321 of 2024 instead of CRR number 323 of 2024. 321 of 2023. In view of this submission made by the counsel for the petition, produce the record. In the order dated 18th May 2026, the number of the case shall be read as CRR 321 of 2023 instead of 321 of 2024. This ought to be treated as part of the order. Item number 2.
No, my lord, in this case, yesterday the matter was part-heard, my lord. My lord has asked them to surrender. The principal accused should be surrendered. The principal accused has not surrendered, my lord. So I pray that, my lord, this matter may be, the application may be rejected.
Why to not this circuit? Yes, yesterday he was there. Yesterday has taken the time.
These things, my lord, cannot be encouraged, my lord.
Sorry. Inform, come. I will pass over. Item number 3.
I beg to appear for the.
Yes.
The application for anticipatory failed. May I take your lordship to page number 40?
Page 40.
Page 40.
Supplementary.
The FIR.
1414.
1/4.
Yes.
Kindly takes up para 2.
Yes.
The FIR has been started for the offences of criminal trespass, cheating, forgery. Kindly takes up para 2. Gist of the allegation is.
This document. Just supplementary.
Oh, supplementary affidavit.
দিয়েছি এটা অ্যাপ্লিকেশনে আছে এফআইআর
Where is this?
I gave to him.
Lordship will find
Yes.
the basic allegation is on the strength of some wrong documents, I am claiming title over the land. Now, I have purchased a land. Kindly refer to my supplementary affidavit. I have placed on record 3 deeds. One deed pertaining to the purchase of the land by my vendor, predecessor vendor in interest. That is at page 20 to 34. Whereby my predecessor in interest purchased the land.
What is the name of your predecessor?
My lord, Kiran Chhetri and Nirmala.
Kumar Chhetri and Nirmala Chhetri.
Which page this is?
Kumar Chhetri
Page 20.
And Nirmala Chhetri.
and Nirmala Chhetri.
Supplementary page 20.
Kumar Chhetri and Nirmala Chhetri.
Yes. Now,
From whom you have purchased? Mahesh?
yes, from them. From that deed at pages 20 to 34.
No.
is the deed.
At 21, matching so and so, 27th of September 2000, between Sri Kumar Chhetri, they are the purchasers.
Yes, ma'am.
Who is the seller? Where is the seller's name?
Durga Prasad Chhetri.
Durga Prasad.
Where is that?
See, Kumar Chhetri.
They are the Kumar Chhetri and Nirmal Chhetri.
They are
the
purchasers.
purchaser.
Yes.
Where is the seller name?
Yes.
Durga Prasad Chhetri.
Durga Prasad
And
Chhetri.
Purchase from one Durga Prasad Chhetri.
Correct. Then
Kindly takes up page 35 to 50. Now I purchased from
35 to
50. This is the deed.
Anjan Roy.
Yes.
You are
I am
the-
on the.
You are the purchaser.
Yes. From
The
Kumar
one part-
Chhetri and
From Kumar Chhetri and Nirmala Chhetri.
Nirmala Chhetri. Yes.
Yes. Then
Then my lord kindly takes page 66 to 67. I sold it out.
No, 51 to 60.
Ah.
51 to
Ah,
Then
51 to 65. And then my lord kindly takes up
Krishna, you sold to Krishna Paddu.
page 18 of the
No, you sold to Krishna Paddu, Krishna
yes,
Paddu.
yes.
supplementary.
But before that,
Ah.
it was kindly takes up page 4 of the supplementary affidavit.
Page
On
4.
the- Yes.
Yes.
Previously, the land was recorded in the name of Kumar Chhetri and Nirmala Chhetri. Kindly see the first column. I applied for mutation on the strength of that deed, and ultimately the land was mutated in my name. Kindly takes up page 5.
Page 5.
Yes.
No objection filed against the claim
Yes.
applicant. They mentioned the requisites and deposited following recorded Khedar number in whose name?
Yes.
What
In
the-
my name.
Where it transpires?
Kindly see the first part. It is written in vernacular on page 4.
Page 4.
Yes. It is in vernacular. Anjan Rai, Pita Manoranjan Rai.
This one, first one.
Yes.
First one.
Yes.
Petition of Siri
Yes.
Anjan Roy.
Yes.
Then
Then, my lord, following the due process of law under section 50 of the WBLR Act, my name was recorded. And it reflects that it was previously recorded in the name of Kumar Chhetri and Nirmala Chhetri. Vidya Khatian number 841 and 842. Can you see?
yes.
Yes. And thereafter it was recorded, can you see this on page 5, 8 decimal from plot number 512 from Khatian number 841 and 842 was recorded in my favor with a Khatian number 3006.
Anjan Roy.
Yes. And
841,
thereafter,
841, 852. Share 130, 0.40, 0.40. Yes. Then
kindly takes up page 18 of the original application. There, my lord, I applied for conversion.
18.
Yes, page 18 of the original application.
Annex of P3.
This is annex of P3. After due,
I just want to clarify.
So you have
Following
applied
the-
for conversion of the land
yes.
from one class to another.
Yes.
Schedule 1 below. Then
That was kindly see, previously it was Rupne. Kindly see, that was converted into Bastu. I applied for conversion, kindly takes up the next page. I was paying the Panchayat Chaukidari tax under the Panchayat Act. And thereafter, my lord, I sold out the land to Krishnendu Paul at pages 51 to 65 of the supplementary petition.
Krishnendu Paul is the purchaser, Anjan Roy is the seller.
Yes.
Where is the schedule?
Alright.
Where is the schedule?
Schedule will be at the last page, ma'am.
What is the total land you have sold?
8 decimal.
Where is that?
At page 40, ma'am.
Page 40.
Yes.
51 is the sale deed.
No,
How
no.
40 will come? Come to the 57.
Yes, ma'am. A moment, ma'am. That is at page 57, ma'am.
Correct. 57.
Yes.
Plot number 512.
512.
Maheshwari, jail number such and so. So what is the total area?
8 decimals.
Where is that?
Malad will find that in 4 kathas or 14 kathas.
Where is that?
At the first part.
Vacant page. Acha, 4 quarters. Yes.
A little less than 8
8
decimals.
decimal.
Now, my lord, kindly see the FIR, what they are saying, that on the basis of a wrong document, I am claiming title over a land which the first informant is also claiming title. An entirely civil dispute, an attempt has been made to camouflage it in a,
Against whom the FIR has been chalked out?
against me and my subsequent purchaser.
To Krishnendu.
Yes, Krishnan.
You are in Krishnendu.
I am Anjan Roy.
No, you and Krishnendu
Yes,
have
yes,
been,
yes, yes,
have been acted, have been described as accused.
yes.
In the last sentence. Even.
Entirely civil dispute, my lord. If they are having any claim over the title till that they have not approached the appropriate civil court. And now, my lord, may I submit that after the e-nothikoron was introduced, there is a website that is called the wbregistration.gov.in. From there, my lord, anybody can have access to the documents, to the registered deeds at any time, on a real-time basis.
This one is next.
Now, they are saying that my deed is false, my lord. On what basis, my lord, they are not saying this?
This is my deed.
No,
Yes.
Just by mentioning a word, false document, without any rational basis, my lord, this FIR was registered for the offences of forgery. Despite of the fact that my deeds are registered, my vendor in interest, that deed is registered, my subsequent purchase of that deed is registered, all are available in the web portal on a real-time basis. The
Yes.
land was previously recorded in the name of my vendor in interest. I applied for mutation. Land got recorded in my name. I applied for conversion. The prescribed authority under the Land Reforms Act, after due verification, converted it in my favor.
Yes.
very interesting case, my lord. First of all, he has rightly, whatever documents he has submitted, so the deed which he has submitted that contains the site plan, the certified copy, that has not been filed. Though it's a supplementary affidavit before a high court, honorable high court. Now my learned defective complaint has helped me out, my lord. What happened, my lord? First, my lord, I have a copy, I'll just read it and then I'll hand over to you. You have a again, sir, clever drafting. Clever drafting. Now, my lord, what happened? This is the land where this is the deed, chain deed of Anjan, where he has purchased the land. This is of 2007. The site plan is there. This is the first page. Very interesting. On the left hand side, the volume photocopy is there. On the right hand is the chain deed, which was enclosed with the copy of the volume. But they have not filed. They have filed a certified copy, volume copy, but they have not filed the site plan because it is against them. Second page, my lord, this is the land purchased by Anjan Roy. First one is the site plan of parent deed of that is of 2007, which was sold to Anjan Roy.
Yes.
Now the third page is the land purchased by Krishnendu Pal, who is another accused person. He has purchased the land where the site plan is different. This is the first one. It's written site plan of parent deed number 2580 up to 26 November 2027, which was sold to Anjan Roy. This is the first one. The site plan is different.
No, then you come to the page 43.
Page
43 of the main appendix,
My lord.
elementary. Page 43 starts from page 36. That is the date. That is the date which from which Anjan Roy has purchased
right,
from the petitioner.
my lord.
From the
These two
Kumar
persons.
Chetri and Nirmala
Yes.
Chetri. Correct.
Yes,
Now that is the now you come to the schedule.
my
Page 43.
my lord.
Page 43.
My lord.
Correct.
This is the second page of this document. my lord.
Second, that's the second
My
page
lord.
of the document. Correct. So here, I don't think there is any difference. I don't think there is any difference.
From which one?
Neither your map nor this map. 43 or this map.
Yes.
There's no
No dispute, no
dispute.
dispute.
There's no
He
dispute.
purchased another land. While selling the land, he has
No, that's
showed-
why.
he has given my site plan.
No, that's why, because this deed Anjan Roy purchased from Chetri.
Chetri.
Correct. And the map which is 43, that is the same map which you are not disclosing in page 2.
My lord,
Correct. There is no
Correct.
dispute on that.
my lord,
I am correct.
my lord.
Yes. Then,
Then when he sold the land,
hmm,
this is as per the deed number, the last one, page number 51.
yes, 51. Krishnendu sold Anjan to Krishnendu.
My lord,
Krishnendu.
just my lord, see the land, both the lands.
Hmm.
The
Where is the
shape
map?
of the land also.
Where is the map?
Map is in the third page of.
Subject to correction, my lord, this is a civil dispute.
That is different thing. Civil dispute doesn't mean
Where is
that the
map?
criminal, there is a bar in the criminal code.
Where is the map?
Of cheating and forgery. My lord, third page of, page number 60, my lord,
Page 60.
my lord, of the supplementary.
Yes. Page 60.
Just my lord, take a look.
And
On
you,
that map,
where is your third? Where is your map? You are telling?
on
Same thing.
the next page, my lord.
Hmm.
That is the details of the deed of Ajit Kumar. This is our map,
Anjan Roy.
my lord.
And page 60. So, see,
And see the my lord, Moja map also, where they have cut the Moja map. So entirely he has purchased the land. Maybe he was not in possession, but he has sold my land. And even the accused number 2, what I've heard from the IO, he's a doctor, he's Dr. Krishnendu Pal. He is also going to start a case against Anjan Roy. Because he has also been.
no, no, from where you are telling that? Kindly come to the page 60. That
Yes,
is the
my lord.
schedule map of the land purchased by Anjan, Krishnendu from the
From Anjan.
petition. Correct. So what is the difficulty in that map?
That map in one side 36 feet,
Yes.
another side 89 minus 1,
Correct.
and these plot numbers are only one, 512.
512.
Hmm.
But here, my lord, if my lord see the sketch map,
Just where is the 512?
Base map of-
Yes,
Plot- plot-
where is the 512?
it's written, my lord, plot number RS,
Plot number RS,
RS
412.
246, LR 512.
Correct.
Actual, my lord, now, my lord, see the what from where, how?
No.
The deed from where Anjan has purchased.
That your lordship will find it, page 40.
That is 36. He is studying 36. Here is 35. Here is 85.8. Here is 84. Here 44. 40. Okay. This map is not matching. 43.
And not
Page
only that,
43.
the 512, my lord, this is a report from the PLRO, my lord.
No.
It is not their land.
Rakho yahan. Kindly come to the 43.
Yes, ma'am.
Kindly come to the
43,
43.
my lord.
Read with 60.
Yes, my lord.
Correct.
My lord.
So this is the map. 43. This is the map purchased by Anjan.
Yes.
43. Got it?
My lord.
And now come to the 60, which the Anjan sold to Krishnendu.
Hmm.
So the length is 35.6.
Yes.
35.6.
More or less
6
30.
inches are less.
Correct. So here the 36.4. 4 inches is less.
Yeah.
Given given more.
More or
And-
less.
My lord, on the west side, the land of Subhash Sharma, here is also west side Subhash Sharma.
Correct. So
But
He had to purchase this land, but he used more.
it is bullshit.
Subject to correction, my
But
lord.
the first,
I will come.
now my lord, the first which the documents have filed, page number 1, that is the parent deed. From there, the interchain is coming. Just see that
See,
that in both sides there are roads. On the west side there is road.
that is correct. Then in that case, then the Chetri should be the accused also. Chetri will be accused. Have you made an application for Chetri being
No.
accused? So the date, the 43 is not under challenge.
Yes.
Correct. 43 is the date entered between Anjan and Chetri. And Anjan and Chetri, this is the map. 35 and 84, that is the length and breadth.
My lord,
And
once
here the map is 4 inch, 6 inch, whatever it is, there is a this is
physical
the
after
only-
physical, that can be.
This is the only thing.
That can be. But thing is that now the Raju, that means that mother, the previous owners, that Chetri, at that time when they sold the land, the site plan which they have given, that doesn't tally with the parent. Otherwise, you are favorable. এবারে মানে কি তোর তো কেস এটাই their case is that actually
My
see,
section is.
সিভিল করতে যা
where is the schedule of the first date?
If your office will find that page.
আপনি কিছু কালেক্ট করেন my lord can go to the scissor list is in the CD my lord scissor
As per
list
the record of the office.
page number
Solution
21 and 22
Ajit Kumar Sanu Prasad is the recorded on 507.
that is the BLO report. The complainant is the owner of the land, recorded owner, 512 LR plot number.
Can it takes up?
What is the question he has put to the BLR?
কি রিকুয়েশনে কি
What is the question he has put to the BLR?
রিকুয়েশন কি দিয়েছিলেন BLO কি জিজ্ঞেস করেছে
Where is the question? Where is the question?
আপনি BLO তে তো একটা রিকুয়েশন দিয়েছেন সেটা বার করে শেয়ার করতে পারেন কি প্রশ্ন করেছেন তার কি উত্তর দিতে হবে
May I visit your lordship?
Prayer.
Takes up page 9.
এটা কি
Listen.
even an illegal electricity connection was obtained from the station manager.
No, that is
different.
that the law is settled. Illegal connection cannot title. You can take appropriate steps in accordance with law. You cannot challenge that. If you find that it is an illegal connection, you can take you can evict the person in accordance. Keep with you.
My lord, these are the এডিএসআর কি বল ডিট তো এডিএসআর কিছু ক্ষমতায় নেই এডিএসআর যার জমি পাবে রেজিস্ট্রি করে দিবে আপনি যদি বলেন হাইকোর্ট রেজিস্ট্রি করে দিতে হবে এই যে কিনতে চায়
Who is Ajit Kumar?
First me from.
The answer which is given, the certified LR plot number so and so attached with so and so as per the W, they are who they are. They are the recorded tenant, they are telling that, na? Recorded owner. Who they are? See, the first answer. First answer.
Report for the
Report first answer. Question.
Is attached with the report as per the and they are.
Who they? Who are they?
The report as per the prevailor. Oh, well, at the next page, the list.
Who are they?
Yes, my lord. All the owners are there.
Who are they? That's what, who are they?
Right. It's a mark, my lord. All these rights.
So if as per the record, the Ajit is the owner as per the record. So where is the cheating?
No, they have sold my land.
Still the land is recorded in whose name?
That is recorded upon at present is recorded in the name of Ajit, sir. His name.
Then where is the cheating?
They have not gone for the mutation. The land which they
That's why it is gone for the
not
not.
the land. which
Just
they
a minute. It is not mutated.
No,
it
they
is
have,
in-
they have done mutation. They have
So
done
you are
mutations.
telling as per the report, mutation what?
No, madam. 507 has several plots.
I am,
Plots in the
see,
sense,
you should not make the confuse. It is only with regard to the deed. The investigation is carrying out with regard to the deed. That's why the IO is so intelligent. He has given the survey number and he is all up. On you have put this. If the, as per the report of the BLRO, if the Anjan, this, what is
Ajit,
Ajit Roy is still the owner, where is the cheating against the?
thing is that, my lord, the 507, this is a big plot of land.
I am asking big plot of land.
This is the information of plot.
That is with regard to 80. What is the total?
512.
No, what is the total area?
3 acres, 6 decimal.
No, purchase.
Purchase is 8 decimal.
8 decimal. So whether the 8 decimal is recorded in the name of the petitioner,
Yes, sir. No, sir. Copy the lesson.
8 decimal is recorded in the name of the petitioner. If it is not recorded, how the criminal case will come?
Well, today they have filed the documents.
Leave aside your investigation, come with the investigation. BLO, you are relying upon the BLO report whether the Ajit Roy is the owner. Still, that's why I use the word intelligence of the investigating officer. When the complainant is behind him, he is with the petitioner, with the complainant. When petitioner, the complainant go out from that, then he is with the accused persons. Deed says something, your report says something. Where is the name? Because it's the latest one.
This is
And
the-
when the deed
this is
was
the 11th of May 2026.
25 and when the deed was executed,
We have much on it prior to that.
then June 2024.
And not only that, this is the mutation case, page number 6 of the supplementary.
That's what mutation case not yet occurred.
When it appears from the petition, see Krishnendu Pal. Yes, he has applied for recording the following schedule on his name. And it is written that seller name is, this is the mutation application.
Correct. Mutation application. Mutation app.
Later it was,
This is a conversion application. Where is the mutation? It is a conversion application. Where is the mutation?
the mutation is in the name of.
Whose name? Then, if it is name, if as on date, the Ajit Roy is the owner of the property, where is the cheating against him? There might be several documents. Where is the cheating against the Ajit Roy? Sir, you are appearing for the complainant. You have drafted the complaint. Correct. Where is the, if as on date, the land is recorded in the name of Ajit Roy? I am asking one thing. If as on date, the plot is in the name of Ajit Roy, where is the cheating?
So you can give only one submission. As per the details of defective complainant, so the schedule or blank schedule of the defective complainant was used. The meter was taken on that land, showing that land it was sold to the Kishan Park. So
That's why, sir,
Please.
please understand. Somebody told me that it has been sold to the X. That is to be ascertained from whom? From the revenue authority. The IO has inquired from the revenue authority. IO has got the record as on date, the 512 plot number is recorded in the name of Ajit Roy. Correct. So it is still the land has not been transferred in the name of the petitioner or Krishnendu. Krishnendu might have been deed executed between the petitioner. Correct. So how you have been cheated? Where is the ingredients of 420? He is not cheated. It is not the case that he has signed the deed as an Anjan Roy and sold to the Krishnendu. Correct. And still the land is in the name of Ajit Roy. If you find that this petitioner or Krishnendu is in your occupation and had obtained the electricity connection, amounts to a criminal 420? Tell me. Tell me.
You're not saying the petrol company reside outside, so he was not unaware of everything that was going.
I fully appreciate.
He returned back. So as per his knowledge, he has placed the complaint before the police officer.
Correct. So now investigation is going on. Correct. Now this is the anticipatory application. What the police, as per the record with the police, is still the mutation has not been carried out. Now you got the date. Now you can take appropriate steps. So if it has not been transferred in the name of the petitioner or Krishnendu, because as per his case, he has purchased from Chhatri.
Yes.
Correct. Then he sold to Anja. He sold to Krishnendu. So, but the record does not reflect whether the Kshetri, he has become the owner at any point of time.
Whether Kshetri has taken the right position.
Right position or not. So that how the IU will accept it.
This is a case of possession, matter, recovery of possession.
Recovery of
Who is in possession? Who is in
and you got the deed.
Joint service.
Now you got the deed. Got the deed. You take steps. The investigation will carry out according. Yes, I am disposing of. The petitioner has filed the present application being CRMA number 296 of 2026 under section 482 of the BNSS 2023 for grant of anticipatory bail. Petitioner. For grant of anticipatory bail in connection with Pradhan Nagar Police Station case number 253 of 2026 dated 6th April 2026 under section 329 within bracket 3/318 within bracket 4/338 within bracket and 338/336 within bracket 3/61 within bracket 2 of the Bharatiya Nyaya Sanhita 2023. Full stop. The counsel for the petitioner submits that the petitioner has purchased the property in question from Kumar Chhetri and Nirmala Chhetri by a registered deed number 2580 of 2007. Full. Subsequently, the petitioner no. Initially, Kumar Chhetri and Nirmala Chhetri sold the land to Durga Prasad Chhetri. Okay. They are the purchaser. Kumar Chhetri and Nirmala Chhetri are the purchasers.
The sellers.
They are the sellers. To Durga.
No. Durga is the seller.
That's what I'm telling. Counsel for the petition submit that Kumar Chhetri and Nirmala Chhetri have initially purchased the property in question from Durga Prasad Chhetri. Full stop. Subsequently, by a deed number What is the deed number? Next, your deed number? By a deed dated. What is your deed number?
2580/227.
That-
And thereafter, my lord, that was Kumar Chetri and
Yes, your deed number. What is your deed number?
9095.
Where is that?
That will, the lordship will find at page 35 of the supplementary.
35. 909. Where is this?
My lord, at the topmost part. And in the last page, my lord.
Subsequently- subsequently-
Page 50.
The petitioner has purchased the land from Kumar Chetri and Nirmala Chetri by a registered deed number 9093 of 2023.
Yes, sir.
2023. 20.
Also, kindly takes up page 50, my lord, there is the entire details.
2023. Subsequently, the petitioner sold the said land to one Krishnendu Pal by a registered deed number 5322 of 2024. 2024. 2024. He submits that the 2024. Subsequent to the, he submits that the petitioner has purchased the said land by way of registered sale deed. And subsequently, the petitioner has sold the said land to Krishnendu Pal. And thus, there is no case made out against the petitioner for the offense, for the alleged offenses, on the basis of the alleged offenses. Full stop. He submitted that the complainant without going through the record has made a false complaint, knowing that the petitioner has purchased the property by way of registered sale deed, and subsequently it was sold to the Krishnendu holder by way of registered sale deed. The learned counsel for the complainant along with the counsel are present. Learned counsel for the complainant submits that the petitioner, the map shown in the alleged sale deed are not correct, and the petitioner has suppressed the map. He further submits that if the map of the sale deed executed between the Krishnendu Pal and the petitioner, and the map of the sale deed executed between the petitioner and Kumar Chetri and Nirmala Chetri, both are different. Thus, the petitioner has sold the land of the de facto complainant instead of the land which he has purchased. And as such, the complainant has made a complaint to the police authority for taking appropriate steps against the petitioner. Learned PP in charge is present along with the IO and produce the CD. Counsel for the learned APP in charge submits that if the map of the deed executed between the petitioner and the Chetris and the map of the deed executed between the petitioner and the Krishnendu Pal is taken into consideration, which finds that the petitioner has sold the land which is not recorded in his name. He further submits that during the investigation, the investigating officer has obtained the report from the BLO and LRO, wherein it reveals that obtained the report from wherein it reveals that the land is recorded in the name of the complainant and not in the name of the petitioner, and as such, the petitioner has no right to execute any deed. Execute any deed. Full stop. Had the learned counsel for the respective parties peruse the materials on record. This court find that materials on record, including the supplementary affidavit filed by the petitioner disclosing the 3 deeds. From the deeds disclosed by the petitioner, which reveals that initially the land was recorded in the name of one Durga Prasad Chetri, and Durga Prasad Chetri sold the said landed property to Kumar Chetri and Nirmala Chetri. Subsequently, the Kumar Chetri and Nirmala Chetri has transferred the said land by way of conveyance deed in favor of the petitioner by way of registered deed. In the year 2024, the petitioner has transferred the said land by way of registered deed in the name of Krishnendu Paul. Full stop. During the investigation, the investigating officer has obtained report from the BLR and BLRO, wherein it reveals that still date the land is recorded in the name of Ajit Roy. Ajit Kumar Roy. Full stop. Ajit Kumar. Full stop. Considering Ajit Kumar, considering the above fact, this court finds that the matter is related to the documentary evidence. The petitioner has already disclosed the document by way of supplementary affidavit by supplying the copy to the learned counsel for the estate, as well as the de facto component. And as such, this court did not find, and as such, this court is of the view that the custodial interrogation of the petitioner is not required. Full stop. In view of the above, the required and the petitioner is entitled to get the anticipatory bail. Full stop. In the event of arrest of the petitioner, the arresting officer shall release the petitioner on bail by furnishing bond of ₹5,000 one surety of like amount. Full stop. The petitioner shall appear before the investigating officer once in a week till the report in final form is submitted. Full stop. The petitioner shall not hamper or tamper with any evidence. Full stop. Any evidence. The petitioner shall appear before the trial court on each and every date of hearing. CRM is disposed of. उसमें बोला ना, shall appear before the investigating officer once in a week and shall cooperate with the investigation. Yes, shall cooperate with the investigation. Yes. Give to my code.
Item number 4. Sure, item number 4, it's prayer for extension of interim order. My lord.
Yes.
It's a prayer for extension of interim order passed by my lord, Honorable Justice Joy Shunmukto.
What is the matter?
So the matter concern is the matter arising out of the matrimonial dispute. The present petitioner.
CR case number. CR case.
CR case number.
Yes. You are the husband.
I am the wife and the relative of and the family member of the wife.
You are the wife and family member of the wife.
Lordship.
Who has initiated the case?
The husband initiated the case.
Husband initiated the
Lordship.
case. What is the offense?
Lordship, actually, the dispute arising out of the 498A case lodged by the present petition number 1 against the respondents. And thereafter, they amicably settled and they turned into a memorandum of understanding by the deed. And thereafter, the opposite party obtained bail. And after obtaining the bail, the respondent denied that thereafter the dispute between the present petitioners and the respondent arising out of again. And thereafter the respondent said that the memorandum of understanding is forced by the present petitioners. And Accordingly, the respondent filed a forgery case against the present petitioners.
Hmm.
And your petitioners are before your lordship to
The petition, the matrix research to be mentioned. To be mentioned? No. Counsel for the petition submit that the interim order is still. March, 23rd March, the interim order was granted for 6 weeks. 6 weeks.
Lordship, actually it is vacated.
Huh?
By the time
So
it is
where is the
vacated.
application?
Lordship, my application is CRAN number 1. Lordship.
What you stated? When
Lordship, kindly a fresh
the
interim-
interim order was vacated?
on 13th of May, Lordship.
Huh?
On 13th of May, it was vacated.
13th of May.
And on the very same date, the petitioner filed
Learned
his
counsel
petition.
for the petition has filed the present application being CRAN 1 of 2026, praying for extension of interim order. He submitted that initially this court has granted interim order on 23rd of March 2026 for a period of 6 weeks. And according the petitioner has filed the present application for extension of interim order. Consider the submission made by the counsel for the petitioner, peruse the application. Interim order is extended till 30th June 2026 or until further order, whichever is earlier. Let the matter placed before the next circuit bench. CRAN 1 of this vote. Next.
I'm grateful, my lord.
Item number 5.
Item number 5 is a civil matter. I am for the petitioner, my lord, but before it completes
One call. Pass your matter call.
2. Item number 2.
Yes. Item number 2, I am appealing for the petitioner.
Yes.
Yesterday, your lordship had taken up this matter when your lordship had expressed.
Principal
your-
accused is not arrested, but
Yes,
what
lordship,
can be
yesterday
done?
yesterday I had submitted that the principal accused will surrender, lordship, but yesterday he could not surrender because his house, from the court, his house is more than 100 kilometers away, lordship.
Hmm.
So today he is going to surrender, lordship.
Ah.
So your lordship kindly take it up next circuit.
Can I record your submission?
Yes,
Then you
lordship.
will in trouble. If I record your
This is
submission.
my instruction, lordship.
Definitely, thing is that, my lord, already in the last occasion, they have faced the case.
What is the section? POXO 6.
No, POXO 6 does not apply against the petitioner, lordship, against the petitioner.
But the
Nine-
problem is that the main accused is not there.
Yes, today he is going to surrender, lordship.
But this can't be, my lord. This can't be.
be done. Then your counsel for the petition submits that he got the instruction that the principal accused is going to be surrendered before the learned trial court by tomorrow, and he prays for fixing the matter before the next circuit bench. In view of the submission made by the counsel for the petition, the case adjourned, let the matter appear before the next circuit.
Item number 5.
Yeah, so it's for the other side.
Mr. Das is.
Go to the next circuit.
No, my lord, not necessary.
When
A
the
small
judgment,
matter, my lord.
when the judgment will be delivered.
I have made a written notes also, my lord.
Written
I'll place
notes,
the
you
judgments.
might be, but
Only
the
two judgments are there. That is also of
the
Supreme Court, my lord.
court has to pass the judgment.
My lord can hear, if my lord thinks that it requires time, that is different thing. But it's a very simple matter, my lord. Last occasion, day before yesterday, I've already
Order
started.
7, Rule 11
My lord, my order 7, rule 11 was rejected
by the
by
Civil
the
Justice
senior
Senior
division, Civil Justice Senior Division, Jalpaiguri.
Ah.
Now, my lord, the prayer, their
Where is the-
prayer was,
Where is the suit? Plaints?
yes, my lord. Suit is in
Page 32.
page 32 is the plaint, my lord. And I'll take my lord to the prayer. my lord.
Specific performance of contract.
Yes, page 40 is the prayer.
In respect of the suit property, more fulfilling, directing all the defendants to execute
My lord.
and place.
My lord, the case,
proposed-
my lord, just to refresh your my lord's memory, my lord, the case is that it was regarding an agreement to sell. There was an agreement to sell between the parties. They are the proposed purchaser and the defendant is the proposed seller. And what happened? The rate was fixed at rupees 22,50,000 per bigha. The total land is of 3.09 acres. That comes near about 10 bighas. But the exact amount was not written. So the land was not ascertained how much land is there.
How much amount he paid?
They paid 50 lakhs. And that is
50
also
paid.
50
Yes.
lakhs paid. The total would be near about 22 lakhs, 25 lakhs. If it is 10
crore.
bighas, total amount. Now what happened at the time of survey, they found that certain 1 bigha of land is encroached by the locals.
For what purpose you want to buy you want to purchase?
That is written in the
What is the
agreement.
agreement?
It's an agricultural land, my lord.
Agriculture.
My
Okay.
lord.
Not
So-
for any business purpose.
No, it's an agricultural land. For that purpose, they had purchased. Later on, they could have, if they can convert the land or that is different thing. But thing is that, my lord, now it is found, they have admitted that the land is in possession of part of the land is in possession of local persons who have already planted mature tea plants are there. So it's in possession for a long time. So now rest of the things were fine, my lord. Now they have asked us to make the land free from all encumbrances, which is not possible. So what we have stated as per the clause, is in the agreement, paragraph, my lord, I think probably paragraph 10.
Where is the agreement?
Agreement, I have, yes, my lord. My
Page
supplement,
5 in the supplement.
supplementary, my lord.
Page 5 is the supplementary.
My lord, I'll take to page 12 of the inside, my lord, the agreement, my lord. It's written, paragraph 9, that if the first party avoids or neglects or fails to perform the act as stipulated and accepts the balance amount of the consideration and fails to execute. So I have not received the balance amount of the consideration. Only a part has been
No,
paid.
but if you have taken the plea that it cannot be registered.
My
it
lord,
cannot be
my lord,
registered.
my lord.
So, okay, it cannot be registered. Okay, the order sound, but what about the amount paid by them?
I'm ready to pay back. I've stated already.
How in order 7
Now-
11 the decree can be passed? with-
No, not decree, my lord. Thing is that on the letter I've already given a notice. We have replied that, okay, fine. First of all, it was said as is, where is basis. Was whatever, my lord, it was not mentioned in the agreement. So on the first occasion, when they served up the notice that they are willing to buy and there is encouragement to make the land free from all encumbrances, at that time we have said, okay, it's not possible for us. It was said it will be sold as in where is basis, because with the local people, it's not possible. And second is that now we want to return back the amount of 50 lakhs. Now, whether they're entitled for the damages as per the clause, because my case is on the basis of the statute that there is a bar under section 14D of the specific relief act.
No, that's correct.
That's correct, my lord. So in that case, my lord, if something is determinable in the agreement itself, my lord, in the contract. is
Determinable. Okay, the court will not pass on a specific performance, but the compensation, the return of.
My
the-
lord, for that, they have to file a separate case, not
No,
this
what-
case. What is
what-
the prayer? Here also, my lord, the Supreme Court has said, my lord, that this is nothing a case of clever drafting, my lord.
No, that's correct.
I should really appreciate my lawyer who has drafted the friend, my lord, who has drafted the plan. I think Mr. Dash was there in the trial court also. I read shit, means what he has done. Suppose he knows this is a case where a 10 rupees stamp paper agreement has been done. Now, it's fine. It has not been registered. Now, in the meantime, during the period of trial, that has to be impounded. So that 2022, the case is pending. Injunction, they have already obtained an order of ex parte injunction. Then we filed order 7/11. Now their injunction application is pending. The original, the temporary injunction application is pending, but they are enjoying the ad interim order of injunction.
What is the interim? Not to.
Not to
Just to-
sell,
not
not
to
to enter,
Not to
not to
alienate.
alienate, everything is there. Now their prayer, my lord, if any of the prayer is, suppose this case runs for another 5 to 6 years, and if the prayer is allowed, whether that can be executed,
No,
whether I can on me, because
that's why-
they have been, whether it is possible, my lord, I have stated.
So that's why I fully appreciate your argument, but the 50 lakhs or whatever he has paid, what would happen to
No,
that?
50 lakhs were ready to pay.
But how in the order 7?
For that, my lord, order 7/11, because my lord, now they are damaged.
See, okay. In the court, okay, they will execute and they will come evidence and all these things and the court is fine, yes, it cannot be.
My lord, we can show our good gesture. We can
That's
pay
why it
50
can-
lakhs to the court also. In the meantime, let it be pending, my lord. We'll
Yes,
come.
what instruction you have?
Yes, yes, my lord.
How the deed will be executed if they are not interested? So what?
No, no, no.
Hmm.
There is no title dispute, my lord.
Ah,
I have never assailed in my plain that there is a title dispute.
ah.
My only direction to them that since I could not enter into the land with the Amin, and that was the condition precedent in the agreement. I like to just refer the agreement.
Correct. No, you are,
why-
whatever the agreement, but prayer in the suit for the specific performance.
My
and
lord,
possession.
my lord, because
And
this is subsisting agreement is there.
admittedly, you are not in possession of the property.
They not in whole. That is the 21 bigha plan. Sorry, 10 bigha plan. Out of 10 bigha, little bit more or less 1 bigha is boundary dispute is there. They cannot take the plea that it is it ought to be determinable or agreement cannot be possible to be executed. They
Okay.
cannot take the plea at the stage of order 7-11. That could be a plea in the written statement and it will be dealt in the trial.
My lord,
Yeah.
now the thing is that, my lord, the prayer which they have made, page 40 of the main application, my lord, a decree for specific performance of contract, which was reduced into an agreement dated 25th of 8, 2021, in respect of the suit property more fully described in the schedule herein below. So this, my lord, this prayer, first of all, a decree for performance which was reduced in writing, fine. What performance they want? That the land, they are going to pay the balance amount. The land has to be registered in their name. And land cannot be made free. This court cannot pass an order against the third party who are occupying that land. They are also having some documents, whatever it is. Now, next, other, my lord, the permanent injunction, these are all consequential reliefs, my lord, which they have asked for. If the first prayer and the second prayer is not allowed, these are all the tail of those prayers, my lord.
Yes, true. Yes. Next.
Now, second is that, my lord, and my lord already mentioned, my lord knows that 14D, that is determinable, my lord, it's contract, my lord, it's specifically determined, contract not specifically enforceable. So where a contract, 14D says that where 14A says where a party to contract obtains substitute, let's correct 14D, a contract which in its nature is determinable. My case is that, my lord, this 14D, my lord, specifically that.
14D.
D, 14D, 1-4. Contracts which cannot be specifically enforced.
No. A contract which is in its nature determinable.
A contract which is to be dependent on the personal qualification of the party that the court cannot enforce specific performance. It's material terms, yes.
So, my lord, wherein the itself in the clause, these are nothing. These are the Supreme Court is very specific about this thing, my lord.
Yes.
I'll be citing two citations. This is 2022 Supreme Court and another is 2024. First 2022, my lord. 2022, 2024, volume 12, Supreme Court cases 723.
Yes.
And another is 2022, volume 12, Supreme Court cases, page number 641.
Yes.
Here, what happened in a case, my lord? The legal heirs of a partner expired, the legal heirs, they have prayed for dissolution of the firm. And which is bar as per the statute.
That is the 43 or 44 of the.
My lord, true, my lord. Now here, there was a clever drafting, my lord. What they have done, they have come for a permanent injunction. They have not asked for any prayer. So, but thing is that their thing was, my lord. Oh, no, it is different. No, my lord, this is different, my lord. The court has categorically stated, my lord. Thus,
Which paragraph?
my lord, the first page of these 2022.
Hmm.
It's after the bold letters.
Hmm.
When court is of view just by reading plaint along and assuming averments made in plate to be correct, that none of the reliefs claimed can be granted in law. These are also the claims which cannot be granted in law. Since plaintiff are not entitled to claim such reliefs, court should reject the plaint as disclosing no cause of action. Reliefs claimed in a plaint flow from the culmination of cause of action pleaded in the plaint. Cause of action pleaded and prayer made in the plaint are inextricably intertwined. In the present case, cause of action pleaded and reliefs claim are not recognized by law. Such a suit should not be kept alive to go to the trial. It has to be nipped at the buds, my lord.
Yes,
Because these cases pending in the courts, they are nothing, my lord.
yes.
And I'll take my lord to paragraph 15 of that.
Yes.
15 says, it could thus be seen that the court has held that reading of the averments should not only be formal but also meaningful. It has been held that if clever drafting has created the illusion of the cause of action and a meaningful reading thereof would show that the pleadings are manifestly vexatious and meritless. In such a sense of not disclosing a clear right to sue, then the court should exercise its power under Order 7 Rule 11. It has been held that such a suit has to be nipped in the buds at the first hearing itself. Now they have paid 50 lakhs.
Yes.
I have an investment on that land.
Yes.
The case is already going from 2022. They are enjoying an order of injunction for not to alienate. And with the amount of 50 lakhs, another 4-5 years it will take to for the, my lord, whatever. Even if the decree is part, that cannot be executed because I am not in possession of part of a land.
Yes.
Is useless, and wherein I have, and the contract says, my lord, the agreement says, my lord, clearly states that paragraph 9 of the agreement, my lord, should take a note of that, my lord.
Why you are telling you are not in possession of the land? You are not in possession.
They have, I am not possession of the entire land. I am not possession of 1 biga of the land.
Only 1 biga.
1
you
biga.
handed over.
Yes, my lord.
What is the total?
3.09 acres. That is near about 10 bigas.
1
And
biga
my
has
lord,
been given to them.
And my lord, section 9 says, if any of the first party avoids, neglects, or fails to perform the acts as stipulated, or except the balance amount of the consideration. So the balance amount has not been detected because they could not take the measurement of the entire land.
Yes.
What is the total amount? Cannot be, and fails to execute and register the sale deed in favor of the purchaser or their nominated or in the name anybody described with respect to, then the purchaser shall be entitled to compel the first party to receive the balance amount and execute. Here the balance amount has not been paid till. How can they come and say ki, until and unless they pay the balance amount, how can they pay for the specific performance of contract on paragraph 9, my lord? Balance amount has not been, only 50 lakhs has been paid to us. Paragraph 9 of this agreement is very important. And now if I cannot give the land to them or register the land to them, then I have to pay 12% damages. Now, regarding that 12% damages, whether they were at any point of time, they showed any readiness and willingness, that has to be taken into consideration. How much damage has been done? What damage has been done to them? Because we have not sold property because already there is an interim injunction. So what damages has occurred to them? Until and unless only they are entitled for 50 lakhs, we are ready, my lord. That is also, I'll take my lord.
Yes.
These are the some email conversations, my lord, email are there. This is, my lord, page number 17 is the letter, first letter by the
17 of
the supplementary. They have request to give, my lord has got it, 17 page, annexed to P6.
Yes.
Request to give registry at the earliest in respect of the below mentioned scheduled property as per terms and agreement for sale on the church. Now, my lord, I will take to the last 6 lines from it has been. It has been observed that their letter they have sent us. It has been observed that some portion, about 33 decimal, that is 1 biga, of the said land is under cultivation of tea plantation run by local people. You will appreciate that we have duly informed about the facts earlier to you, and on some occasion you asked to solve the issues earlier, but till date it has been unsolved because we cannot solve that issue. Now, in reply, what we have stated, the next, that is page number 20.
Yes.
Page number 20. My lord, each of the there are several petitioners, my lord. Each of the petitioners has sent a separate email, my lord. So these are all I'll just read one, same, all are same. my lord. I am in receipt of your letter in regards to the sale agreement of land measuring 3.00. See, the schedule of the properties agreement. As per our discussion and mutually agreed upon, we have decided the rate per bigha on and where basis. They may say that this is the first time you have come with a point as and where basis. But this on the first occasion when we received the letter, that was a talk going on, although it is not in the agreement. As is basis and all of the formalities regarding demarcation and boundary shall be your responsibility.
Yes.
It is quite separating. Please note that I, along with the other, ready to execute the deed on immediate basis. We have stated we are ready. Please note that I, along with my other members, are ready to execute deeds on an immediate basis, subject to the SDA as per purchase deed. Whatever the areas there at the purchase deed, that means with the 1 bigha disputed land, we are ready to sell 3.09 acres of land. If you are agreed, you can buy.
Yes.
You pay the balance amount. Now, these are all serial melon. Now, another is page number 28.
Yes.
Here also it is stated that, please note that initial discount mutual agreement as and when basis, same thing. And the last paragraph says, in case you are not willing to complete the agreement, please also share the bank details so that we can return the advance received from you after deducting 20%. That is our case. That as we are facing problem, we said I will be paying you the 50 lakhs after deducting 20%. This is the letter. Then my lord, they send another letter that is page number 30. No, it is the same. No? That is same, my lord. They have stated that it was never stated that as is was basis. And paragraph number 3, page number 32.
Yes.
Be that it may, we are very much interested, ready and willing to have the bilateral land and property registered in name of our firm by paying the balance amount of mutually aggregate sale proceed. As in the meanwhile, the time to hand over the land and property has already been delayed by all of you before that. Please do the needful for a clear, unambiguous demarcation of the land. We are fully ready to cooperate if required, and since by your mail dated you have unilaterally proposed for completion of the registration by within 24 months, then please complete the measurement and demarcation. Their thing is that they are pressurizing us to do the demarcation. We are saying it's not possible. Land is already been occupied. So if you want to buy the entire land, you can buy and then you handle the whatever regarding the dispute. They are not willing to that. They want a clear, free from all encumbrances. Now what we can do in this case, and we were ready. We have stated that we are ready to return you the amount. So now, my lord,
Yes.
and regarding another thing is that, my lord, that the suit filed in 2022, 2021 agreement, that is also has to be taken into the unregistered deed, my lord, that will be only for the purpose of collateral. If they go for a money suit, that they have paid the money, that is one of the proof. But if they come for specific performance of contract, that has to be registered. Unless and unless it is registered, my lord, this is 2020, this is on 2024 Supreme Court, my lord.
Yes. Which paragraph?
Now here, apart from the specific performance of contract, my lord, they have also asked for a perpetual injunction, a permanent injunction. So here, if it is a 10 rupees stamp, suppose the first prayer is not allowed, but the third prayer, which is a perpetual injunction, that can be granted on the basis of unregistered agreement, my lord. They have an alternative prayer also. So here Supreme Court says no. It says original plaintiff instituted a suit praying for degree for permanent injunction only which was claimed on the basis of an agreement to sell. First paragraph. However, agreement to sell was unregistered documents, agreement to sell on 10 rupees stamp paper. Therefore, such an unregistered documents agreement to sell shall not be admissible in evidence. Having been conscious of the fact the plaintiff might not succeed in getting relief, a specific performance of such agreement to sell and the same was unregistered, plaintiff filed a simpliciter for permanent injunction.
Right.
It may be true that given and unregistered documents can be and considered for collateral purpose. However, at the same time, the plaintiff cannot get relief indirectly, which otherwise she cannot get in a suit for substantive relief. The substantive relief is specific purpose of contract. Namely, in present case, relief for specific performance. Therefore, plaintiff cannot get relief even for any kind of injunction also.
Yes.
On basis of such an unregistered document, agreement to sell. More particularly, when defendant specifically filed counterclaim for getting back possession, which was allowed by trial. My lord, one word we use every time in a criminal court at the time of quashing. That if the case doesn't stand at the time of trial, why should it be pending? Same.
Yes.
This is the same principle of law.
Anything further?
My lord,
What the trial court has heard?
they have rejected my
What
application.
what is the observation? What is the finding?
Elaborate observation.
What is the finding?
He has not appreciated anything, my lord. I have also.
No. He has appreciated. And he has considered everything and elaborate order has been passed. I will come back in the order sheet.
Elaborate order doesn't mean that everything has been considered. There should be a quality, not the quantity of the orders.
Last document of the main application. From page number 4, the observation of the court.
Trial court has misdirected itself by holding a mini trial, my lord.
Yes. Yes. Any further?
In conclusion, my lord, only thing is regarding the cause of action.
Yes.
My lord, the plaintiff discloses no cause of action for specific performance
Why?
due to impossibility. My lord, there is a boundary dispute. Even the opposite party has admitted, the plaintiff itself, that there exists a boundary dispute, and that portion of the suit property, approximately 33 decimal, is under the cultivation of possession of the third parties, local tea plantation worker. Now, Your Honor, my lord, thus, if the court grants a decree for specific performance which directs the seller to deliver actual khas and physical possession of the property, where the seller on the face of the record does not have the capability to deliver such possession due to the third party occupation there, my lord. Number one, specific performance is a discretionary equitable relief, my lord. Equity does not compel a party to do that which is impossible to do. And the third is, in a suit for specific performance, the decree operates in personam. If the defendant cannot deliver vacant possession due to the admitted physical possession by third party, the relief is a futility. This is the application principles of the citation which I have given of Rajendra Bajaria ratio, my lord. Paragraph 17. Paragraph 17 of the, my lord, yes, ma'am. It has been, paragraph 17, my lord. It stated that it has been held that if the court finds that none of the reliefs sought in the plaint can be granted to the plaintiff under the law, the question then arises is as to whether such a suit to be allowed to continue and go for trial. The court answered the question by holding that such a suit should be thrown out at the threshold. My lord, the plaintiff's remedy is for the damages or refund of the honest money. Now, whether they are entitled, which the defendant is willing to pay, my lord, not enforcing the specific performance, that is impossible to execute. This is my case, my lord. Only in, my lord, though, my lord, I have just written notes, my lord, if it's matter. Copy লাগবে না।
No, no, written note. You are
আমার লাগবে না
submitting.
copy, আমার লাগবে না।
No, no, you have to submit. You have to
I'll give a
submit
copy.
the-
I'll WhatsApp you.
Yes.
Yes.
Grateful, my lord.
My first very little scope of order 7 rule 11, because Lordship will appreciate that at the stage of order 7 rule 11, we have to take the plaintiff as a gospel truth along with the documents.
Correct.
Nothing else. No defense, no case of the defendant, no other documents. Save and except the documents that has been relied at the time of presentation of the plaint, that has to be relied by both the sides. Because stage is 7-11. That 7-11 order was passed 1 year back. That's why one application can has been filed. Though I appreciate
No, in
that
227
yes,
it's not required, my lord.
I appreciate that in 227 no limitation is there, but that must be within a reasonable period. But time and again, why I have submitted this thing, time and again they have submitted suit is pending since
What is
2022.
the stage in the suit? It's still the WS not filed.
Yes, WS has been filed.
WS file, it's fixed for
WS filed.
hearing of the temporary injunction.
Because in the meantime, they have, after getting the injunction order, they filed one application under 39(4) that was considered with the same plea, same more or less same contention of the defendant, that was heard and rejected. Thereafter, they filed this 7-11 with the same more or less contention. Now, my submission that what is the prayer in the plaint, what is the contention of the plaint, and what is the document, I like to first bring the notice of the court regarding the agreement to sell. That is very vital and important document.
Yes.
Agreement to sell that has been annexed with the supplementary affidavit.
Yes. Yes.
Yes. Page number 2, that is the parties, vendors, defendant. Page number 3, that is the plaintiff, purchaser, intending buyer. In the first paragraph, second paragraph, third paragraph, entire page 4 and page 5, how the defendant
Got the
intending
property.
here they got title, it has
Got
been
the property.
clearly mentioned. With the specific line in each of the paragraph that they have got their transferable right title interest therein. In an every paragraph,
Yes.
having permanent heritable transferable right title interest. Now, I am coming from page number 6, my lord. Whereas in the second subparagraph, whereas said vendor now being in need of money has offered to the purchaser for sale of all that aforesaid piece and parcel of land measuring in total 3.09 acre as described and fully described in the schedule below, and forming part of this presence together with all right, title, interest therein, and which is free from all encumbrances.
Yes.
Whereas the vendor above named have agreed that the purchaser for the sale to him or them at the price of rupees 22,50,000 per bigha. Amount is defined. How the submission has been made, that amount is not been defined. I failed. What is the requirement? Total amount is this, the 22,50,000 will be per bigha out of for the total land of 3.09 acre. Now, the condition clause. Very important. Now, this agreement witness that the first party being in need of money have firmly and finally decided to sell the land offered for sale of the said land measuring in total 3.09 acre, forming part of this present together with all right and interest. That the purchaser being in need of land of that area has agreed to purchase the said area of land and offered for a price of rupees 22,50,000. 3. First party considering the price to offered as fair and reasonable highest in view of the prevailing rate have agreed for the transaction. 4. In persons of the aforesaid offer and acceptance agreement, purchaser have this day paid to the first party a sum of rupees 50 lakhs as earnest money or baina, the receipt wherewith is acknowledged by executing these presents.
Yes.
Next paragraph. Paragraph number 5, clause number 5, my lord.
Yes.
That a thorough searching is to be made by the registry by the purchaser. Liberty has been given to the purchaser for a thorough searching. And if any discrepancy is found in any document or a claim, objection regarding the title or possession of any part of the above land is made by anybody, first party vendor will be liable for solving all such claim at their own cost, and only after such rectification, final payment shall have to be made by the purchaser to the vendor. Unambiguous, clear.
Yes. Next.
Now they are taking the plea that I am not in a position, so you refund, you get back the amount. Whereas it is the duty clearly entrusted upon the intending vendor.
Yes.
That if there is any dispute, because at that time, my lord, I am an intending buyer.
Yes.
You are the vendor. You know better every pros and cons of the land. I, on being bona fide consideration of your word, I have agreed to purchase with a clear term that if there is any dispute come, I at the time of execution of the agreement, I may not know everything. That's why the liberty is given that thorough searching is to be made. Next, B, that the purchaser shall have full right to make some cleaning work in the land or some land filling, if so required, and the scheduled land is to be demarcated by demarcation cemented dhalai. Dhalai means boundary wall, by the purchaser of the scheduled plot of land during the period of this agreement at his own cost. However, if any discrepancies is found in any document or a claim objection regarding the title or possession of any kind of above land made by or during the above said field work or during the period of this agreement, first party vendor will be liable for solving all such problem claim at their own cost, and only after such rectification, final payment shall have to be made. What guilty I have made, my lord?
Okay.
It is the question to myself that what is the fault of myself?
Okay. Next.
Next, purchaser shall pay the remaining balance
That are the
amount
conditions. That are the
at the
conditions.
time of purchase. So,
Yes.
please. So, I have to pay the balance amount when these two conditions will be fulfilled, specifically written. That's why no date of mode of payment has been specifically mentioned in the agreement, that after 2 months, 3 months, 15 days, whatever may be, I have to pay this amount, by which it can be asserted that I am a defaulter. I, being a bona fide purchaser, I have paid a 50 lakhs at the time of execution of the agreement without searching even the title and possession, and you are taking the plea that the land is not in your possession. That paragraph number 7. First party shall execute necessary sale deed.
No, come to 5B.
5B.
5B, last 3 lines.
Last 3 lines, yes.
The first party vendor will be liable for solving all claims of their own cost. And only after such ratification, final payment shall be made by the purchaser to the vendor.
Right.
Correct.
Right.
So he has to solve all the problems.
All the problem.
Now kindly come to the 6.
Yes.
That the purchaser shall pay
The remaining balance amount at the time of registration of the scheduled property,
which shall be completed within 3 months from the date of execution of this present.
Time period is there.
Yes, right? So 3 months means 25th August, that agreement has been made. 25th August. 25th August, September, October, November.
Correct.
25th November.
Correct.
I on several occasions tried to enter into the land for the purpose of dhalai, for the purpose of cleaning work, and for the purpose of measurement. That's why, from my part, I requested the vendor by sending one notice that please. That no, that I could not enter into the land. So take proper initiative for solving this dispute. That was my first letter. I like to refer that letter. It is annexure P6, dated 21st, page, my lord, page number 17 in the supplementary petition.
Seventeen.
17, my lord. 17. my lord.
Yes.
Subject: request to give registry at the earliest. The heading. Sir, in respect of the agreement, the letter was written by one of the partner of the plaintiff for sale executed on August 25th, 2021 between such and such. It is pertinent to mention that we have already paid at rupees 50 lakhs in advance. However, as mutually agreed, on several occasions, we tried to measure and demarcate the land for the purpose of getting actual boundaries and ascertain the total land, that is 3.09 acre, sold to us with clear demarcation through an amin. But all our efforts for the same resulted no conclusion.
Okay.
For lack of cooperation from your side.
Okay.
So the stage is order 7 rule 11. I have clearly mentioned in my plain that I on repeated occasion requested you to resolve this problem. You did not came forward to resolve the problem. Now in the stage of order 711, you are taking the plea that I am ready to pay the entire amount, return back.
No.
And the problem is regarding only 1 bigha, more or less. It may be little, it may be less. So remaining 10 bigha is there. You are enjoying that property, enjoying my 50 lakhs for last 3 years.
Yes.
And now taking the advantage that though I am a wrongdoer, but I want to get rid of this problem. A wrongdoer cannot take the advantage of his own wrong. That is the settled principle.
Yes.
So
Next.
my submission, Your Honor, that the stage of order 7 rule 11, it cannot be ascertained that whether the agreement is determinable or not, because that is a specific case of defense.
Yes.
that could be at least a case of order 14 rule 2.
Okay. Next,
So,
any further?
yes. Lordship will appreciate that that plain case and and the document relied upon at the time of presentation of plain will be the Adjournment at the time of this test. Regarding this matter, I like to refer one decision, that is 2012 8 SCC 701, paragraph number 15 and 16. এখানে। 15.
Yes.
Law has been settled by this court in various decisions that while considering an application under Order 7 Rule 11, court has to examine the averment in the plain. Only averment in the plain, and the pleas taken by the defendant in their written statement would be irrelevant.
Yes.
So there is no
settled law.
The settled law.
Yes.
All the argument that has been placed by my learned friend, that is the case of the defense.
Yes. Next.
This is 2024. Yes, 24. Volume 11 SCC 503, my lord. I am referring paragraph number 16 and 25. (16) in page 510, my lord.
Yes.
Sorry. In Kamala versus KT Esharia, this court opined that for invoking clause D of Order 7 Rule 11, only the averment in the plain would be relevant. One thing, my lord, for a minute, I like to pause here, because one argument has been advanced that there is no cause of action.
Yes.
And we know for the purpose of the scope of Order 7 Rule 11 is very limited. For my satisfaction, I like to refer the Order 7 Rule 11 for, and this is
Yes.
the plain shall be rejected in the following cases.
Yes.
Only for scope. Number 1, where it does not disclose the cause of action. In my suit, in paragraph number 2, cause of action means bundles of facts, but in clear terms, in paragraph number 13, I have mentioned the cause of action of the suit. Paragraph number 13. That cause of action of the suit arose in respect of suit property which is located within the jurisdiction of this learned court earlier on 25th August 2021, when the plaintiff and the defendant of the suit, by making an advance payment, had completed the oral agreement for sale of the suit property, the term of which were reduced into writing by executing a formal deed of agreement, and therefore on some occasion when the plaintiff asked the defendant to make the entire suit land free from all encumbrances, and finally when the plaintiff got the notice dated 25th February and other information that the defendant are intentionally making delay for registration of the sale deed and cause of action is still going on every subsequent day. So in clear term, I have mentioned the cause of action, though it need not to plead in a single paragraph, it has to be gathered from the context. Paragraph number B, condition B, where the relief claim is undervalued. It is not undervalued. The plaintiff, on being required by the court to correct the valuation within a time to be fixed, it is not the case. Where the relief claim is properly valued, but the plaintiff is written upon paper
Is only with regard to the
only
D.
regarding A and D. A and D.
Correct.
D is where the suit appears from the statement in the
Is
plain
barred
to be
by
barred
any.
by law. And even in case
So
of
is cases with regard to the no cause of
only
action,
one
and the agreement cannot be
enforced, cannot be enforced.
or the court cannot pass a decree for a specific performance where it is with your knowledge that some of the portion is in occupation of third party.
A little portion. Little
Right, some of the portion is a third party. Once it is third party, the court cannot pass a decree under the specific relief act and 30.
That's why the
So that's why
yes,
it
yes.
is case.
right. That's why the condition has been specifically imposed that
Okay.
if there is
That's
any
why-
boundary dispute.
As per your case, in the agreement, all the things has been specified. He has paid you have paid 50 lakhs.
On
And it
this
was
condition.
agreed that he made the landed property full on incumbrances. If any problem is there, he will solve the problem. Once
Then-
it has been solved, it has been given to you. You will make the dhala or the concrete over
And
there.
final payment.
And thereafter you make the payment and within 3 months.
with
then
the
you can
register
register
the
deed. That is
That is the
condition.
simple case. So
Yes.
in the
Yes.
in paragraph number 16, it has been written that court opined that in invoking clause D of order 7 rule 11, only the abandonment in the plaint is a delay.
That's
Settle. Now, the no cause of action or defective cause of action. It has not been categorically mentioned that whether I don't have any cause of action or I have any defective cause of action. If there is any argument for defective cause of action, that is a pure case of written
Right.
statement. Defense. No cause of action only on the ground that clever drafting has been made. On repeated occasion, this term has been mentioned because settled principle of law by the apex court that when it will be apparent from the pleading that there is a clever drafting, it will be deemed to be a no cause of action. But from the category of the plain that has been on board in our hand, where is the clever drafting? Where this from this document from the plain it will be gathered that I don't have any cause of action. Only mere submission that the plaintiff has no cause of action, that does not come within the purview of order 7 rule 11 A. You have to come with a specific case that this is the clever drafting. From this drafting you cannot assert the definite cause of action.
Yes.
That has not been agitated.
Okay. Next.
And I like to submit another decision, 2025 SCC. Volume 3, page number 513. I like to refer paragraph number 23 and 24 at page 536.
Yes.
Twenty-three, 24, 25.
Yes.
In that case, Your Honor, it was the case in that particular case that
Yes.
agreement has been terminated and there was no specific plea in the plain, though it is not in our case. So the agreement cannot be enforceable. And plain ought to be nipped into bud since no declaration has been prayed for. That is a settled principle in another matter. In paragraph number 24, However, in the interim, I.S. Sikandar was also considered by this court in A. Kanthamanti versus Nasrin Ahmed, and it was held that former decision turns on the fact involved therein is thus distinguishable. In the latter decision, this court also held that it is well settled principle of law that a plea regarding the mentality to the suit is required to be raised in the first instance in the pleading, that is the written statement. And then only such plea can be adjudicated by the trial court on its merit as a preliminary issue under Order 14 Rule 2. Once a finding is rendered on the plea, the same cannot be examined by the first or second appellate court. What follows in paragraph 25 from A. Kanthamanti is that unless an issue as to be maintainability is framed by the trial court, suit cannot be held to be maintainable at the appellate stage only because appropriate declaratory relief has not been paid for. So, the whole submission that my suit is not maintainable due to the frustration of agreement, that is a pure case of defense.
Yes,
It cannot be agitated at this stage of Order 7 Rule 11.
correct. Yes.
And whether the agreement has been already been frustrated before the suit has been filed is a question to be trial. Pure question of trial.
Okay. That's all.
By mere at a glance perusing of the plain and the document only of the plaintiff, it is not possible for any court of law to ascertain that plaintiff is vexatious.
Okay.
So,
Any further?
yes, that's my submission.
Okay.
That whole submission of
Yes.
the plaintiff has depended as no.
First of all, regarding the no cause of action.
Hmm.
The plain fails to, Malad, here state paragraph 13.
Yes.
The plain fails to state a clear legal right or an infringement of the right that warrants a court remedy. That is not. Second, my lord, is word by law. The statement in the plains unequivocally shows that the suit is because I have already stated section 4, as per section 40B of the specific law, it is word by law.
Okay.
And third is he had the scope also, the relief which he has claimed, he has the scope to correct that, that has also not been done.
Okay.
Humbly pray, my lord, that this bid case should be allowed, my lord, and Order 7 to 11, that order will pass.
I am extremely sorry, my lord. One intelligence. I am referring also section 49 of the Registration Act, where the proviso has been clear that an unregistered document affecting immovable property and required by this act for the transfer of property 1882 to be registered may be received as evidence as a contract in a suit for specific performance of contract.
The collateral values.
No.
Yes.
It's a
The-
specific performance of contract.
The defendant slash petitioner, the petitioner slash defendant has filed the present revisional application being CU 51 of 2026, challenging the order passed by the Learned Civil Judge Senior Division, Jalpaiguri, by order number 30 dated 12th of February 2025, wherein the application filed by the defendant under Order 7 Rule 11 of the CPC was rejected. Full stop. Mr. Neela Chatterjee and Chakwati, learned advocate appearing for the petitioner slash defendant, submits that the plaintiff has filed the suit praying for a specific performance of contract with respect of the agreement dated 25th of August 2021 of the suit property. Full stop. He submits that as per the agreement, the plaintiff agreed to sell the land, measuring an area of 8
document.
0.39. What is
Yes,
the
my lord.
total area?
Yes, 3.09 acre.
3.09 acre. 3.09 acre. At the rate of rupees. At the rate of rupees 22,50,000 per biga. Per biga. Full stop. At the time of execution of the agreement, the defendant has paid the advance amount of rupees 50 lakhs with the condition that the remaining amount shall be paid at the time of registration of the sale deed, or if any at the registration of sale deed. Full stop. He submit that though it is mentioned that the plaintiff is ready and willing to ready to purchase the land at the rate of 22,50,000 per biga, but the total sale consideration has not been mentioned in the agreement. It is the further contention of the defendant of the petitioner that the some portion of the land, that is about 1 acre,
No, 1 biga.
1 biga out of the total area of 3.09 acres,
Which is 10 biga.
is in occupation, that is 0.09 acres is in occupation of third party, and as such the deed cannot be executed in favor of the plaintiff. Thus the court cannot pass an order for grant of for a specific performance of contract. In support of his submission, the plaintiff has relied upon section 14 within bracket small d of the specific relief act, wherein it is mentioned that a contract which is in the nature of determinable, the contract not specifically enforceable. By referring the said provision, the learned counsel for the petitioner submits that in the present case, the total land is not free from all encumbrances, and as such, it is not possible for the defendant to execute the deed. Thus, the court cannot enforce the agreement through the specific performance of contract by passing a decree of a specific performance of contract. And counsel for the petitioner submit that the plaintiff has also not disclosed the cause of action for filing of the suit. He further submits that in paragraph 13 of the plaint, the plaintiff has mentioned that the cause of action arose, cause of action for filing the suit arose with respect to suit property which is located within the jurisdiction of this court. But the plaintiff has not disclosed when the cause of action arose for filing the suit, and thus the suit is not maintainable and is liable to be rejected. Full stop. Learned counsel for the petitioner submits that it was informed to the plaintiff, defendant Learned counsel for the defendant submits that it was informed to the plaintiff that it is not possible for the defendant to execute the deed as some of the portion is not free of the portion of the property in question is not free from all encumbrances. And it was also informed to the plaintiff that the defendant is ready and willing to return the amount of rupees 50,000 by deducting, that is by deducting 20% of the deed value, as the plaintiff is enjoying the interim order since the filing of the suit and the defendant is not in a position to enjoy the property due to the interim order obtained by the plaintiff. In support of his submission, learned counsel for the defendant / petitioner has relied upon the judgment in the case of Balram Singh versus Kelo Devi, reported in 2024 volume 12 SCC 723, and submits that in the present case also submit that this court even cannot grant the decree for permanent injunction, wherein the first prayer of the plaintiff is for grant of decree for specific performance of contract. Full stop. The defendant has further relied upon the judgment in the case of Rajendra Bajoria and others versus Hemant Kumar Jalan and others, reported in 2022 volume 12 SCC 641, and submits that if clever drafting has been created, the illusion of cause of action, and a meaningful reading thereof would show that the pleadings are manifestly vexatious and meritless in the sense of not disclosing the clear right to sue, then the court should exercise the power under Order 7, Rule 11 of the CPC. If further some relying upon the said judgment, the petitioner submit that in the present case also there is no specific cause of action has been disclosed by the plaintiff for filing of the instant suit. Learned counsel for the petitioner further submit that clause 10 of the agreement provides that if any defects in the title is found in the property in question, the seller must refund the consideration with compensation if the purchaser has suffered actual loss. He submit that in the present case also, where it was duly informed by the petitioner to the plaintiff that some portion of the property is not free from all encumbrances, and the suit is not, and the defendant is not able to execute the decree and is ready to return the amount by deducting the 20% of the total value, but instead of the same, the plaintiff has filed the present suit. Per contra, learned advocate appearing for the plaintiff respondent submits that while deciding the application under Order 7, Rule 11, the court has only to restrict with regard to the pleadings in the plaint. He submit that in the plaint, the plaintiff has categorically mentioned that in paragraph 13 has mentioned that the cause of action of the suit in respect of the suit property is located within the jurisdiction of this court, and on 25th of August 2021, when the plaintiff and the defendants of the suit making an advance amount had completed the oral agreement for sale of the suit property, he submitted that an agreement was reduced in writing by writing, and the plaintiff has paid the advance amount of rupees 50 lakh. Subsequently, the plaintiff has several times informed the defendants that the plaintiff is ready and willing to purchase the property by executing the sale deed by paying the balance amount, but the defendant has not come forward for registration of the sale deed. Thus, the plaintiff has categorically mentioned about the cause of action in the suit, in the print. Full stop. Learned counsel for the plaintiff has further drawn the attention of this court to the agreement entered between the plaintiff and the defendant on 25th of August 2021, wherein the defendant had agreed to sell the property, the land bearing land measuring an area of 3.09 acres for a 09 acre at the rate of 22 lakh 50,000 per biga, and on the date of the agreement, the plaintiff has paid an advance amount of rupees 50 lakhs. 50 lakhs. Full stop. He further relied upon he further pointed out the agreement and submit that in the agreement it is categorically mentioned that the defendant, being the seller, will be liable for solving all such claim at their own cost, and only after such rectification the final payment shall be made by the purchaser to the vendor. He submit that. Full stop. He further submits that in the agreement it is also mentioned that the scheduled land is to be demarcated by demarcation, and the cemented dhali is to be carried out by the plaintiff, and carried out by the plaintiff, and the defendant will be liable for solving any such claim of the said land at his own cost. Only after such rectification the final payment shall be made. Full stop. He submit that though in the agreement it is mentioned that the remaining balance amount shall be paid at the time of registration within a period of 3 months, and accordingly the plaintiff has sent a notice to the defendant on 21st of February 2022 calling upon the plaintiff to complete the deal for purchase of the land as per the negotiation of the sale consideration as soon as possible. And once the demarcation and boundaries are determined, the plaintiff will be in position to get the physical possession of the total land. Full stop. Counsel for the plaintiff, in support of his submission, has relied upon the judgment in the case of Bhau Ram BHAU Ram versus Janak Singh and others, reported in 2012 volume 8 SCC, and submit that it is settled law that while considering the application under Order 7 Rule 11 of the CPC, court has to examine the averments of the plaintiff, and the pleas taken by the defendant in the written statement would be irrelevant. He further relied upon the judgment in the case of Aldico Housing and Industries Limited versus Ashok Vidyarthi and others, reported in 2024-11 SCC 503, and submits that the court, while invoking clause D of Order 7 Rule 11 of the CPC, only the averment of the plaintiff would be relevant. Full stop. He further relied upon the judgment in the case of R. Kandaswamy versus T. R. K. Saraswati, reported in 2025 volume 3 SCC 513 and submit that in the said case also, in the said case, the Honorable Supreme Court has held that the maintainability of the suit is required to be raised in the first instance in the pleading within bracket written statement, and then only such plea can be adjudicated by the trial court on its merit as preliminary issue under order 14 rule 2 of the CPC. He submitted that instead of taking the plea of maintainability, the defendant has filed an application under order 7 rule 11 of the CPC for rejection of the plaint, and accordingly, London trial court has rightly rejected the application filed by the defendant. Had the London counsel for the respective parties peruse the materials on record and the judgment relied by the parties. Full stop. It is settled law that while deciding an application under order 7 rule 11 of the CPC, the court has only to look into the plaint and its averment and the documents relied by the plaintiff. Full stop. In the present case, it is the case of the plaintiff that the defendant is the owner of the property of the suit property. Full stop. On 25th of August 2021, the plaintiff and the defendant have entered into a sale agreement with respect of the suit settled property, wherein the defendant, being the owner of the property, has agreed to sell the said land to the plaintiff for a total sum of rupees 22,50,000 per biga. And at the time of execution of the sale agreement, the plaintiff has paid rupees 50 lakh as advance amount. Full stop. In the agreement, the description of the property has been categorically mentioned how the defendant has acquired the said land. In the agreement, it is also mentioned that heritable and transferable right, title and interest therein are free from all encumbrances. Full stop. In paragraph 5A and 5B of the agreement, the defendant, being the seller of the property, has categorically stated that the seller will be liable for solving all such claims at their own cost, and only after such ratification, final payment shall be made by the purchaser to the vendors. Full stop. In paragraph 5B, it is further mentioned that the defendant, being the seller, is liable for solving all such claims against all such claims on their own cost, and only after such ratification, final payment shall be made by the purchaser to the seller. On 21st of February 2022, the defendant has sent a notice to the defendant requesting to registration of the sale deed. In the said notice, the defendant and the plaintiff has has informed the defendant that the plaintiffs are ready and willing, are completely ready to complete the deal for purchase of the land as per their negotiation, sale consideration as soon as possible once the demarcation and the boundaries are determined, comma, the plaintiff and will get the physical possession of the land shall be paid to the defendant. Full stop. There are several correspondences were made between the parties. On 9th of March 2022, the plaintiff, the defendant, by an email, has informed the plaintiff that the plaintiff are not willing to complete the agreement. So by an email dated 9th March 2022, the defendant has informed the plaintiff, that the plaintiffs are not willing to complete the agreement and requested to share the bank details so that the defendant can return the advance received from the plaintiff after deducting 20% of the sale value. Full stop. The defendant has also taken the plea at the time of argument in the present application that the plaintiff has filed the suit with regard to on the basis of the sale agreement, but the agreement is not registered, and as such, without the registration or without impounding the said agreement, the court cannot pass the decree for grant of specific performance. Full stop. This court finds the full stop. So this court case, it is the specific case of the plaintiff that the plaintiff has entered into an agreement and has paid balance amount, and he is ready and willing to pay the remaining amount, subject that the suit property should be made free from all encumbrances. Admittedly, the suit property is not free from all encumbrances. It is the admitted case of the defendant that some portion of the suit property is occupied by some third party, due to which the court cannot pass an order for a specific performance. This court failed to appreciate the submission made by the counsel for the defendant. It is the matter of trial whether the defendant can prove before the learned trial court whether the land is not free from all encumbrances. Merely on saying that the third party is in occupation of the property in an application under Order 7, Rule 11 of the CPC, the court cannot adjudicate the same. Full stop. From the reply, from the email dated From the email dated 9th of March 2022, it also reflects that the defendant is not ready to execute the deed and he intends to return the amount by deducting the 20% of the deed value. That is also the matter of trial, whether if the court cannot pass an decree for specific performance, whether the defendant is entitled to get the balance amount back, or the defendant is entitled to deduct 20% of the sale deed value. Deed value. It is not the case of the defendant in the present case that the defendant is ready and willing to return the 50 lakh rupees along with the interest. It is also not the case of the defendant that the plaintiff is enjoying the property. Only the case made out by the defendant that the defendant could not enjoy the property as the plaintiff has obtained the interim order from the court. Interim order from the court. Full stop. In the agreement, it is the specific clause that it is a specific clause that the defendant will make all necessary arrangement for get the land free of encumbrances, and thereafter the land will handed over to the plaintiff, and the plaintiff will get the land fenced from all corners and will pay the total sale price at the time of registration of the deed. In the present case, it is the case of the plaintiff defendant that the land is not free from all encumbrances, and it is admitted that the land has not been given to the plaintiff, handed over to the plaintiff, and thus this is the matter of trial. Whether the defendant intentionally has not handed over the property to the plaintiff, or whether actually some third party is in occupation of the property in question. As regard the cause of action is concerned, this court finds that this agreement was entered between the parties on 25th of August 2021. On 21st of February 2022, the plaintiff has sent a notice requesting the defendant to come for informing the defendant that the plaintiff is ready to complete the deal for purchase of the land as per their negotiation as soon as possible, and requested the defendant to demarcate the boundaries and to give the physical possession. But the plaintiff has different full stop. In paragraph 13 of the plaint, comma, the plaintiff has categorically mentioned with regard to the cause of action. It is mentioned that the plaintiff got the notice dated 25th of February 2022 and other information that the defendants are intentionally making delay for the registration of the sale deed, and the cause of action is still going on every subsequent dates. Considering the said averments made in the plaint, this court finds that the plaintiff has categorically mentioned the cause of action for filing of the suit. As regard the registration of the sale agreement, this court finds that both the parties have acted upon the agreement. The plaintiff has received the part sale consideration amount, advance sale consideration amount of 50 lakhs. Whether the agreement is admissible in evidence or not, that is required to be considered at the time of evidence. Under Order 7, Rule 11, this court cannot adjudicate whether the agreement relied by the plaintiff is admissible in evidence or not. Considering the above, this court finds that this court did not find any illegality in any perversity in the order passed by the learned Civil Judge Senior Division, while passing the order number 30 dated 12th of February 2025. Accordingly, the order is upheld revision is dismissed.
Grateful, my lord. Grateful.
Sorry.
Grateful, my lord.
Bad case,
उसको